This video was created and brought to you by ManageMax. We manage condominiums, HOAs, manufactured housing and apartment communities throughout Southeast Michigan. We're a growing company, and maybe we'll get to your area soon if we're not there yet. We create these videos to share industry insights with current and prospective clients. There will be an opportunity to connect with us at the end, so stick around to the end of the video. Now let's dive in. One resident needs an emotional support animal. Another resident has severe pet allergies. Both have disabilities, both have rights under federal law, and your board has to make a decision that's going to make one of them feel discriminated against. Welcome to one of the most legally dangerous situations in community association management. Here's how it usually starts. Owner A submits a request for an emotional support animal. They have documentation from a healthcare provider. They have a legitimate disability. Under the Fair Housing Act, you're required to consider a reasonable accommodation even if your governing documents prohibit pets. Then, owner B contacts the board. They live in the same building, maybe even on the same floor. They have severe allergies to pet dander, allergies that are themselves a recognized disability. And they're asking, how can you approve an animal that's going to make me sick in my own home? Both residents have legitimate needs. Both are protected under federal fair housing law, and your board is caught in the middle with no clear path forward. Your governing documents won't help you here. This stopped being a pet policy question the moment disabilities entered the conversation. Now it's a federal civil rights issue, and you're the one who has to navigate it. The Fair Housing Act requires housing providers, including condo associations, to grant reasonable accommodations for people with disabilities. But reasonable doesn't mean automatic. It means weighing the burden the accommodation places on others against the benefit to the person requesting it. Here's where it gets complicated. Denying an ESA request just because another resident says they're allergic without any documented reaction is probably not defensible. Courts have been clear that the mere possibility of allergies isn't enough to deny someone's disability accommodation. But what if there's documented allergic reaction after the animal arrives? Now the analysis changes. Now you're weighing an actual direct threat to someone's health against the owner's need for the animal. The line between these two scenarios, potential reaction versus actual reaction, is exactly where lawsuits happen. And whatever decision you make, someone is going to feel their rights were violated. Most boards try to find a middle ground, maybe restrict where the animal can go, maybe require HEPA filters or allergy mitigation measures, maybe limit the animal to certain common areas. These sound reasonable, but who decides what's actually reasonable? You? The residents? Their attorneys? The court that eventually hears the fair housing complaint? Every communication you send about this situation, every meeting minute, every email exchange becomes potential evidence. If you get the analysis wrong, or even if you get it right, but document it poorly, you're not just facing an angry neighbor, you're facing federal fair housing complaints, legal fees, and potential liability for discrimination. Good intentions don't protect you here. The Fair Housing Act doesn't care that you were trying to be fair. It cares whether you follow the proper framework, and most volunteer boards don't even know what that framework is. Competing accommodation requests are among the most legally dangerous situations a community association board can face. The Fair Housing Act doesn't give you a clear answer. It gives you a framework that requires careful expert application to your specific facts. This is not a decision you make based on what feels fair. This is not something you figure out by Googling or asking other board members what they did. This is exactly the kind of situation where you need professionals in your corner, legal counsel, experienced management guidance, before you make a decision you can't undo. If your board is facing competing accommodation requests, or if you're unsure how to handle any disability-related accommodation issue, get help before you respond. The cost of getting it wrong is far higher than the cost of getting it right. If you found this perspective valuable, we invite you to connect with us. Facebook viewers, like our page and follow us for regular updates. Feel free to message us directly with your questions or community challenges. Instagram viewers, hit follow and feel free to DM us with your questions or community challenges. YouTube viewers, subscribe to our channel and check out the video description for helpful links. Visit our website to discover our thought leadership content, books, and resources that can transform your community management approach. Whether you're dealing with the challenges we discussed today or other community issues, we're here to help. Thanks for watching, and we'll see you in the next video.